So, you just lost a loved one, and now someone tells you you'll need to go through probate. And you're thinking, what does that even mean? And why are there two different kinds of probate, summary and formal? If that sounds like your situation, stick with me. I'm going to walk you through what this means in the state of Florida and how to know which type of probate is the right one for your family. I'm Mitch Green, an estate planning attorney here in South Florida. At Kramer Green, we help families navigate the probate process with clarity and compassion, especially during emotionally difficult times. If you're unsure about probate or need help figuring out where to begin, give us a call. We're here to help. Let's start with the basics. When someone passes away owning property that isn't jointly owned, doesn't have a beneficiary designation, or wasn't made payable on death or have a similar designation, then that property has to go through the probate court before it can be passed on to the intended beneficiaries. In Florida, there are two kinds of probate, summary administration and formal administration. Here's the difference. Summary administration is the faster, simpler option, but it's only available in a few situations. Under Florida law, you can use a summary administration only if either the value of the estate's probate assets is less than $75,000, excluding the primary home, or the person passed away more than 2 years ago. Now, even if the estate is small, summary administration might not work if there are a lot of debts or complicated assets that need to be dealt with before anything is distributed. What is the upside of summary administration? There's no personal representative appointed. It typically wraps up in 3 to 6 months, and beneficiaries usually get their shares sooner. Now let's talk about formal administration. That is the full version of probate. It is required when either the estate is over $75,000, the death occurred less than 2 years ago, or when complications make a summary administration unworkable. In formal administration, the court appoints a personal representative, usually the person designated in the decedent's will. This person gathers all the financial information, notifies creditors, deals with debts, and oversees the distribution of the assets. It's more involved and court supervised, which is helpful when there are disputes between family members or unclear asset issues. Typically, formal administration takes anywhere from 6 to 18 months and costs more due to the additional steps and legal work involved. Now, I know what you're thinking. Well, Mitch, who files for all of this? Here's a quick rundown. If you're going the summary administration route, any beneficiary or someone named as a personal beneficiary in the will can file the petition. However, in a formal administration, several people can file the petition to commence probate, including the person named as the personal representative in the will, any beneficiary named in the will, the surviving spouse, any heir at law, or even a creditor of the estate. The key is getting the process started promptly. In formal administration, there are time limits and notice requirements that need to be met. So don't wait if you think probate is necessary for your loved one's estate. Now, what about creditor claims in a summary administration? In Florida, creditors typically have a 2-year statute of limitations to bring claims against the deceased person. After 2 years, all creditor claims are barred, and probate assets can be distributed to beneficiaries without the formal creditor notice requirements. This is why if the person has been deceased for over 2 years, creditor claims do not need to be addressed in summary administration proceedings, and there's no cap on the estate value for summary administration eligibility. Now, what about creditor claims in a formal administration? In Florida, in a formal administration, it is more straightforward. However, there's no way to avoid notifying the creditor if it is less than 2 years from the date of death of the decedent. In such situation, creditors generally have 3 months from the date the notice of administration is first published, or 30 days from the date they're formally served with notice, which is required in the case of known creditors to file a claim against the estate, whichever is shorter. So if there's debt involved, timing counts. Probate is not a one-size-fits-all situation. Whether summary administration is an option or you're facing a formal administration, it's important to understand what's ahead and have the right team guiding you. At Kramer Green, we help you sort through the legal details, protect your family's interests, and handle the paperwork so you can focus on what matters most. If you've lost a loved one or you're planning to make things easier in your family, give us a call or visit our website. Let's talk through your options and put a clear plan in place.